All right, hi again. Welcome back. Attorney Steve Vondran. Welcome to another exciting episode of Litigation Whiteboard. It is today, Thursday, February 27th. Today we're talking about the top 5 things to do when you get a cease and desist letter. All right, without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay. So when you get a cease and desist letter, whether this is to you individually or to your company, you don't want to panic, but you do want to take caution. You do want to be prudent. Here's a couple things that I would do if I got a cease and desist letter, or I would advise my clients to do. 1, do not ignore. Some people think that, hey, if you just throw it away, out of sight, out of mind, the problem will probably just go away. Some people will look at a letter and they go, this looks like scam. I'm not going to deal with it. Or, you know what, this is BS. Put it on the back of put it on my file. I'll get it whenever I get to it, but this is BS. Tip 1, do not ignore. This could be a problem. This could seriously affect your legal rights. The party that sent it may say, you know what, we're just going to sue them. And that could lead to a problem that you could have easily rectified had you took action early, okay? Tip 1, do not ignore that cease and desist letter, okay? Number 2, read the letter carefully. What are they saying? Who is sending this? Is it your competitor? Is it somebody you don't know? Is it cease and desist about trademark infringement, copyright infringement? What do they want? What are they asking you to do? Are they asking you to pay money? Are they asking you to take down photo images? What exactly are they asking you to do? And another important thing is deadlines. Are they imposing deadlines? Now, a question I get a lot about deadlines is, do we have to comply by that deadline? Typically, I'll say it's an arbitrary deadline. Lawyers will set arbitrary deadlines so that it keeps the case moving, so they can put it in their calendar, look for a response by this date, so forth and so on. So you don't always need to follow them. I'm not going to tell you not to follow them. This is not legal advice. This is general legal information only. But look to see if there's any deadlines. If you can comply within the deadline, that always makes a lot of sense as well. Okay? Next, number 3, investigate. Investigate. What does that mean? What is your legal position? Do you have any defenses? Or are they telling you, for example, take down that image because it's copyright infringement? You say, well, hold on, that is fair use. Or somebody says, you breached the contract, you owe us all this money. You're going, well, what? You're the one that breached the contract, not us. So look and see what claims they're making, see what your legal position is. Many times that will require legal research to see what is the case law, what is the statutory law that is impacting your fact pattern, what is at issue, what are your legal defenses. So take your time. Usually you're given plenty of time. Sometimes you get 7 days, 10 days, 14 days, 30 days to respond to demand letters. Again, keep that in mind, but take some time to investigate your legal position. Of course, if you need a lawyer, you can seek a lawyer here to help you, so forth and so on. Okay. Next, number 4, out of my top 5, what to do when you get a cease and desist letter. Number 4, preserve the relevant evidence. If you have a defense, if you have text messages, documents, emails, stored documents, things in cloud, whatever the case may be, if there are things that can help you, always you want to consider preserving the status quo. Now, many times in a cease and desist letter, the attorney or the other party will ask you to preserve all potentially relevant evidence. It's a good thing to follow that. And again, this is where you may want to get your attorney involved. It's a good thing to preserve the evidence, because what happens? If you go into court, you end up in litigation on the case, state or federal court, and you say, well, I deleted the evidence. And I could tell you, especially in federal court, that doesn't go over so well. So preserve all the potentially relevant evidence, especially those that are helpful to any defense that you might be raising, okay? Some people would create a task force. What are we going to do? Let's put together a team real quick. Let's all come to the conference room. Let's talk about the issue. Okay, so all that is in here. Investigate, preserve the relevant evidence, so forth and so on. And finally, consider your options. You could hire a lawyer. You could say, we don't need a lawyer. You could say, we think they're right. Let's just comply. You could say, I don't think they're wrong. Let's send a nasty letter back. Those kinds of things can happen. And finally, one of the other options is what we call a declaratory judgment. So somebody is threatening to sue you, this, that, and the other. You can always consider filing what's called a declaratory judgment action. I believe I do have a video on that. If so, I'll put it down below in the description area and you can check that out. I think I do. But declaratory judgment, where you're asking the judge, if, for example, say someone's calling you a trademark infringer, you're infringing the trademark. You say, well, Judge, I'm not infringing the trademark, so because they're threatening me, I'm going to tell them that if you don't back off, I'm going to seek declaratory judgment with the court that I am not an infringer, okay, that there's a case and a controversy that should be resolved, okay? There's special rules for that. I don't want to get into it here. But these are the top 5 things to consider. Then if you're going to respond, make sure you're responding within your deadlines, so forth and so on. But folks, this is a good general overview of what I like to look at anyway. The top 5 things I like to consider when there is a cease and desist letter requiring a response. So don't panic. These things are usually solvable. Many cases would settle out of court. Sometimes there's a legitimate dispute. Sometimes there's not. It's important to always know the difference and to not just go off the handle and go, keyboard warrior, da-da-da-da-da. So anyway, if you need help, you know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Got to run. Have a great day now. Make sure to subscribe. We got some more great content coming fast and furious here at Vondran Legal.